Yes, let's open the meeting and let's start talking to the people.
All right. Anyone available?
Well, let's do Brushy Brook first. So Bill Landry, I don't see him on there. So do you want to go to solar real estate then?
We could do that.
All right. Hamza, I'm gonna allow you to talk. If you can unmute yourself, Hamza. There you go.
Good evening. Can you hear me?
Hello?
Hang on one second. Hey, Jeff, can you turn that up? We can't hear him. Can you?
Good
turn-
evening. Can you hear me?
Barely. Hang on one second.
No problem.
Which one are we doing?
Try it again.
Solar real estate.
Good evening. Can you
There
hear me
we
now?
go.
Good evening.
Good.
We can hear you now.
Good evening, Mr. Chairman, members of the board.
Yeah, my name is Jeff Hall. Welcome to the Tax Board Review. What we typically do is, we have you speak either, on behalf of yourself or your client. And then we have the tax assessor offer her suggestions. And then we have a meeting, Mike and I will have a meeting after and just discuss it and sort of come up with a decision. And then you will be notified as to what our decision is.
That sounds great, Mr. Chairman.
So if you'd like to go ahead and begin, I'd like to hear what you have to say.
Well, thank you very much for your time this evening. I hope everybody is doing well. My name is Hamza Chowdhury. I'm an attorney, and I'm appearing on behalf of Solar Real Estate Holdings regarding Plat 3 Lot 0053D. I just wanted to give a brief history to help the board understand our argument today in the context. The property is currently assessed at $2,969,300, which represents a $1,350,000 increase from its previous assessment. So just by way of background, the property was acquired on February 2nd, 2018. It was developed into a solar array, and the certificate of occupancy was issued by the town on December 12th, 2019. The project went online a few weeks later on December 31st, 2019. That date coincides with the date of the revaluation in the town of Hopkinton. As a result of the CO being issued and the project going online, at that time, a new assessment as of 12/31/19 was issued in the amount of $1,750,700. So there was a substantial increase as of 12/31/19 as a result of the CO being issued and the project going online. Now, all property, as you know, Mr. Chairman, was revalued in the town as of 12/31/19. So it was appropriate for the town to revalue it and revalue the subject property as of 12/31/19. However, now we come to the current assessment under appeal, which is 12/31/20, which is tax year 2021. The town issued a revised assessment in the middle of the tax cycle in the amount of $2,969,300 without any trigger for the reassessment for tax year 2021. In other words, there was no change in the property in tax year 2021 to justify an increase mid-cycle, especially a $1.35 million increase. As a result, we are before you tonight arguing the following as our basis for our appeal. Number one, that the property has been illegally reassessed in the middle of a revaluation cycle without proper justification. Two, the assessment is selective, arbitrary, and discriminatory in violation of Rhode Island law. Now, there's recently, as of November of 2021, the Rhode Island Supreme Court came out with a case, Athena v. Pear, which reaffirmed the test for a selective, arbitrary, and discriminatory assessment. The Supreme Court has instructed that selective assessments occur when the municipality singles out one taxpayer or a small group of taxpayers for the revaluation when similar property is not assessed for any tax liability. We have reviewed all the similar projects in Hopkinton and have found that there were no increases like the one occurred by my client across all solar projects in the town. Third, the assessment is illegal because both the land and the tangible property is being taxed. Effectively, my client is being taxed twice. This might be a similar argument as the board might have heard previously, because there's a case that's currently pending, an unrelated case, in the Rhode Island Supreme Court on this very issue. So we're preserving it depending on how the Rhode Island Supreme Court rules on that matter. Fourth, we wanted to bring to your attention that there will be legislation that will be reintroduced this session into the General Assembly to address taxation on green energy projects, which may impact this project assessment. It was introduced previously. It passed through the Senate, and I do not believe it got through the House because I believe they ran out of time to do so. Moreover, fifth, the subject property has been disproportionately assessed in comparison with similar projects in the town, and we've done that analysis. And finally, the subject property is overvalued. So that essentially concludes our argument. I'm happy to answer any questions at this time.
I have a lot of questions, actually. When you got the CO, what date was that?
It was December 12th, 2019.
And at that point, the taxes went up how much?
It went up to $1,750,700. I believe the previous value was $305,000. So from $305,000 to $1.75 million.
Yeah, that was just the raw land.
Yeah, the 300,000.
The land before you developed it
Correct.
was 350, but you paid 1.6 for it, correct?
Correct. Yep.
5. All right, so the 1.7 isn't out of line.
I didn't suggest it was.
What was that?
I said I didn't suggest it was.
He didn't suggest it
You
was
didn't
out of
suggest it
line.
was.
Okay. But then once you got it up and operating, it went to 2.9.
No, so it was the project went online on December 31st, 2019.
Okay.
And as a result of it going online and the CO that was issued, it was reassessed at that time to account for the project going online. And that's that $1.75 million value.
Hey, I'm pretty sure that you sent in, you were speaking of the you said it was illegal for them to do that. Did you send some information about that?
I included the basis for our appeal in the application for appeal.
Yeah, all right. It says both the land and equipment have been taxed.
Yeah, they were taxed as of 12/31/19. And then again, it appears mid-cycle without any trigger for a reassessment because there was no change in the property. As of tax year 2021, it illegally increased another $1.35 million. Do
You have anything to say?
Me?
Yeah.
Yeah.
John, do you have anything? Are you done, sir,
I am.
so far? we're gonna let the tax assessor speak and then,
Of course.
Go ahead, Jen.
Good evening, members of the board. My name is John Majika, I'm a former assessor here, and I'm filling in temporarily as assisting the current tax assessor. There's a couple of points I'd like the board to understand.
John,
What? Is that better?
That's a lot
Understand
better.
what- better? Okay.
Thank you.
You know, shall I repeat the first part? I'm John Majika, the former tax assessor, and I'm helping out the assessor's office for these appeals. There's a couple of points I want to bring forward. The property previously was residential. It was changed to commercial special. At that point in time, it triggers an increase in value due to the change in the status of it. It goes along with all commercial properties in town. Second of all, had we known that that was online on 12/31, the valuation would have been assessed at the full value of the 2.9 at that point in time. The office did not get the information until after, when the CO was issued. So when a CO was issued, it means the property is being used to its full potential. So up until that point in time, the valuation was half. Once you go online, the valuation jumps to 100% of being used. So I see nothing wrong with the former assessment or changing it halfway through. That's when it's triggered. Actually, well, I won't say anything about that. I don't believe it was illegally assessed. It wasn't selective, wasn't arbitrary. It affected all the people that had received commercial special zoning changes, not the whole town. Anybody who had their land changed from residential to commercial saw an increase in their value. With all the information that we had provided to us by the revaluation company, which has the expertise in valuing solar projects, the valuation was determined by them on the per acre value for 100% being used and 50% being used. If these companies had provided us with information as to the upfront cost they paid to the people they're renting it from or when they're owning it, the income is generated from this facility, would have a better understanding what the value of the property is really at. But we have no information provided to this office to otherwise change the valuations that were set. Oh, and as far as the court case in North Kingstown, I don't have the details of that. I don't know what it involves. That is a whole separate issue in my book until it is pertinent to these hearings. Any members have any questions? You have to excuse my talking tonight. I had surgery today on my mouth that I'm a little fuzzy.
Oh, no, you're good.
We can hear you.
You're good.
Nice and clear.
Oh, it doesn't feel like it's
Better
clear.
than talking
You
with
should have heard me 2 hours ago.
May I respond to one point?
Please.
Sure. So one thing, and I thank the former tax assessor for his comments and insight. One thing I wanted to flag for the board that the former tax assessor stated that anybody who went from residential to commercial was impacted. Respectfully, that's not what we're talking about here today. That was the previous tax cycle. We're here talking about tax year 2021. That the property went from residential to commercial back in 2019. So I don't think that that's relevant to what we're talking about here today.
So you're talking about the valuation change in mid-year, going from the 1.3 million to the $2.9 million?
That's correct.
Again, we have, when a CO is issued, it triggers off a change in the assessment to bring the property to full value. That happens with every single property in town under the proration law. But in this case, when you change the value to being online, then we change it in our records to reflect that it's actually producing the income for which it was intended, which it was purchased for.
And to that point, I just wanted to remind the board that the CO was issued by the town on
Right.
12/12/19. So, and that was incorporated in the increase that we saw in tax year 2020. So that the town has already taxed us for the issuance of the CO.
They were taxing you at 50%
Of what it's worth.
of what it was worth. That's my understanding.
That is not my understanding, respectfully.
Even though the CO was issued on 12, where I have 12/12, it does not mean you were online. The assessor, because I wasn't here at the time, may have gone out and looked and saw that it was not producing electricity. That's why she didn't raise the assessment up. We have another project in town that I went and looked at a couple of weeks ago, right at the end of the year. The panels were all up, they were all there, but they were not hitched into the grid. Once they get hitched into the grid this year, their value will change to 100% as opposed to the 50%. So we're treating everybody exactly the same.
Okay. Mike, do you have any questions?
No, I don't. I think we'll just have to go over this.
Yeah, we're going to discuss this
Yeah.
after the meeting, and then we will have the town get in touch with you and let you know what our decision is. Is there anything else you'd like to add?
No, Mr. Chairman, thank you very much for your time. Have a wonderful evening.
You as well. Thank you. Who's up next?
Let's see. Helen. Hang on. Okay, Helen.
Hello, can you hear me?
Yes, we can.
You can.
Welcome to the tax board review. My name is Jeffrey Hall. Typically what we do is have you present your case. We then have the tax assessor discuss it with us. And then if you haven't, you're welcome to add to that as he's going along. And then after the meeting, Mike and I will discuss it and come up with some sort of a decision, and the town will notify you as to what our decision was. So if you're welcome to go ahead anytime.
Thank you so much. Good evening, Mr. Chairman and member of the Tax Board of Review. My name is Helen Anthony from Handy Law LLC, 42 Waybosset Street, Providence, Rhode Island. Tonight, I'm here representing HML LLC and Green Development LLC with regard to their appeal of the tax year 2021 assessment of property located at 310 Main Street, Plat 4, Lot 25. By way of background, the property is 136.84 acres. 68 acres are zoned commercial and 68.84 acres are zoned industrial. So Green Development entered into a long-term lease with HML LLC for construction and operation of a 10.63 megawatt solar development, which is located on approximately 67 acres of the property, and that happened in April of 2019. The solar development was complete and operational in December of 2019. Prior to the construction of the solar development, the town of Hopkinton assessed the value of the whole 138.84 acres at $497,900. After the solar development was complete in 2020, the town assessed the value of the whole 138.84 acres at $1,786,500. And that increase, and what I use is the Vision Government Solutions property card. So the increase was due to the increase in value of the 67 acres upon which the solar development is located. And I know that because the property tax card says that the 67 acres were valued at $22,500 per acre with the notation to be solar. Then in 2021, the assessed value of the whole parcel increased again to $3,301,000. And again, the increase was due to the increase in the value of the 67 acres. Now those 67 acres are valued at $45,000 per acre with a notation solar farm. So I think it's clear that the increase in value is due to the location and development of the solar array on the 67 acres. There hasn't nothing else has happened with the property. So our argument is that the increase in the valuation is illegal. And the reasoning behind that is the renewables are manufacturing equipment and as such are exempt from taxation. And that is the case of DePasquale versus Swipe, which I think your tax assessor just mentioned as the case in North Kingstown. So at that point, the court did rule that renewable energy equipment was manufacturing equipment and it was exempt from taxation. So notwithstanding that exemption, pursuant to Rhode Island General Laws 44-5-3C, municipalities may tax renewable energy only pursuant to rules and regs that will be established by the Office of Energy Resources in consultation with the Division of Taxation after the rules are adopted. So what happened after that is the Rhode Island Office of Energy Resources adopted rules and regulations for commercial renewable energy systems, and those became effective on January 1st, 2017. And they established a tangible tax formula that municipalities must adopt by ordinance in order to tax renewable energy. Hopkinton passed an ordinance adopting that tax formula, which is $5 per kilowatt, which results in an annual tax bill right now of $53,150. And that's a tax bill for the equipment. So if renewable energy projects can only be taxed by an ordinance adopting OER's formula, then the classification and valuation of the underlying real estate cannot include the tangible asset. I think you just heard Hamza, Attorney Chaudhry before me, say that it's basically a double taxation. So the underlying real estate is being taxed as well as the tangibles on top of the real estate. And so the underlying real estate has to be taxed as if those tangibles aren't there, which in this case, according to my calculations, based on the valuations of the property, the 68 acres that is not hosting a renewable energy, the adjusted unit price is $3,000 per acre. So in other words, it needs to revert to whatever the value of the property was prior to the solar development being located there. The purpose of the OER's rules and regulations was to create a clear, simple framework that provides both municipalities and developers certainty regarding taxation of renewable energy systems, increasing the value and reclassifying the underlying property hosting a renewable energy system solely due to the presence of the renewable energy system is leading to an unauthorized increase in taxation of renewable energy systems that is both in conflict with the OER's rules and regs and undermines the certainty that OER set out to achieve. An additional tax on underlying property could make the project economically unfeasible. So to be clear, HML and Green Development are not challenging the town of Hopkinson's right to assess the property under the renewable energy system. We're just asserting that the real property tax must be valued as if the land did not host a renewable energy project. So it's a little different argument than my Attorney Chaudhry's argument. We are merely saying that this this increase in valuation of the property under the renewable energy development due only to the presence of that renewable energy development is illegal. So our firm currently has the tax appeal that is currently pending before the Rhode Island Supreme Court. It's a case out of Lincoln, and it is clearly talking about this very specific issue. And we are just ready right now. We're hoping to have a scheduling order shortly. And there is also, as Attorney Chaudhry just said, there's proposed legislation that was introduced at last year's legislative session, which will be introduced again this year. And that legislation confirms that OER intended only to have the renewable energy taxed as tangible property and prohibits an increase in the valuation of land upon which that property, tangible property, is located. So we're hoping that in one way or the other, either through the Rhode Island Supreme Court or through the legislature, that we will be able to have this issue resolved.
Okay, Mike, do you have any questions?
No, I do not.
We're gonna have the tax assessor speak now, and then we'll get back to you in a moment.
Yeah, I'm a little confused by the state law. On one hand, they're saying it's tangible personal property. On the other hand, they're saying it's manufacturing equipment. Well, it's either got to be one or the other. Either it's tangible or it's manufacturing. I don't believe it is manufacturing equipment. The definition of manufacturing under the federal statute is taking a product, taking a substance by mechanical means, transferring it to a finished product. There is no mechanical process in the solar system. I mean, the solar arrays, but that's an argument for another day. I think the state needs to get this straightened out first, but we're assessing everybody the same way across the board on the value when it's approved for development and then value when it's online. Everything conforms to the standards. And if, how do I say this? With every business entity, let's take a cell tower, for instance. Cell towers are taxable, they're tangible, they're attached to land, but the equipment on there is not taxable by state law. But the value of the land is still increased because it's a money-making venture. It's the same with the solar. They are there to make money, and they should be paying a fair share like everybody else in the commercial section of this town. And I see nothing in it's been done by this office to say that it was done wrong. I think everything has been done evenly and fairly across the board for all the solar arrays.
The one thing that comes to mind, I mean, the 67 acres is now, that was residential, correct?
I'm not sure what the zoning was. That was the old Pew Farm or the Cottrell Farm, one or the other. And I'm not sure what the zoning was at the time. I know when Joe Rando bought the other property, I know some was turned into commercial, but I don't know offhand exactly what it was, but I could find out and get back to you.
Yeah, because I mean, if it went from residential into commercial, then there's going to be
There's going to be an increase in value. And if I recall, that land formerly was in the Farm Forest Open Space Program, which had even a lower value. And you know the Farm Forest Program.
May I just respond?
Of course.
I agree that, you know, there has to be, if the property, and it's very hard for me to see because I can't get my hands on the property cards in 2017. So I'm really not sure how it was zoned. I mean, I agree that if it's coming out of farm, forest, and open space, there is going to be a new value. That is, I think, entirely within the jurisdiction of DEM in terms of how that should be revalued. But that's an argument, I suppose, for another day. So I do agree that if it came out of farm, forest, and open space, of course, it does have to be assessed to value, but that value cannot be at all related to a location of a solar development or the solar development being located on the property. The other point I'll make is that the case of De Pasquale versus Swike very clearly says that renewables are manufacturing equipment and as such are exempt. So what I'm saying is that happened with that case, but then the state carved out, you know, they came in and said, well, you know, we hear you on that, but we are going to set the rules for how renewable energy equipment is taxed. And that happened after the Swike case. So it is really, in my opinion, something that has to be either straightened out by the Supreme Court or by the legislature, because our firm has a number of cases pending before Judge Leach in the tax appeals, and he has been staying all those cases until we have some sort of resolution of this issue.
So on your addendum, it says applicant's opinion of value, other improved land, 67 acres at $3,000 an acre. That's for the actual solar farm?
Well, I can tell you where we came up with that figure, and it's the best we could do in terms of what we think it should be assessed. So in the land line value section, again, I'm looking at, I don't know if you have the property cards in front of you.
I
But
do.
okay, so they have on the second page, card 2 of 2, I think third page, they have a land line valuation for, the 60 acres that don't host the renewable energy project. And there is a unit price of 15,000, but then the adjusted unit price is 3,000 per acre with a total value for 204 on 68 acres that do not host the project. So that's basically where we came up with the 3,000. If you understand where I'm coming from.
Yeah, yep, okay.
Okay.
Mike, any questions?
No, I don't have any.
Okay, so we'll discuss this after the meeting and we will get a decision back to you.
I so appreciate everyone's time. Thank you.
Thank you.
Thank you.
Okay, take care.
Good evening.
Robert Craven first. Robert, if you can unmute. And I kind of have these in an order in your packets. So if you want to do Gordon Excavating first. I don't know if you've.
Mr. Craven, did you hear my opening statements or do I have to go through that again?
No, I heard it. Thank you.
All right, so please begin whenever you would like.
I'll take it in the order in which it appears in your agenda according to the clerk.
Yep.
And I should tell you, since we're in Hopkinton and this is Rhode Island, I'll tell you, this was Don Gordon's property and it was John Teff's property on Skunk Hill, Lisa Lane, and Arcadia Road, respectively. It is all one project. It is just 3 parcels that are taxed as separate parcels that are part of one single solar manufacturing facility that is now before the planning board and we won't be back there till May. And so in reference to potentially getting a CO, I don't know, we could be a year away from that. And I would not be surprised. There aren't any panels on this property. There's nothing on this property. There's on John Teff's land, there's nothing that's been cleared. It's exactly as it was before they knocked the house down.
Okay.
So the 3 values, Gordon Excavating Inc., previously assessed at $134,700, and it was 19.2 acres. The new assessment, $250,000. It's an 85% increase, or $115,300 in value. Don Gordon's property on Lisa Lane, it was previously assessed at $251,600. The new assessment, $569,100, a 126.19% increase, an increase of $317,500, and that's 57.2 acres. And John Teff's property, Hopkinton Land LLC, it has been purchased by the company that I represent. It's at 145 Skunk Hill. Previously, it was assessed at $615,900. Its new assessment is $970,500. A 57.7% increase, a $354,600 increase in dollars. That property is 171,000 acres. Excuse me, yeah, 171, not thousand, 171 acres.
Okay.
Here's the interesting thing, and I'll deal with these three as one property. We have in hand a ruling by the town council after having had a hearing before the planning board, where we received a temporary zone change for the period of 35 years for installation of a solar array. And at the end of that 35 years and the decommissioning goes back to residential property. So we have temporary use for solar arrays only. And how dense, how much, where it's located is all yet to be decided by the planning board. And that's their decision. They can't say no, but they can certainly place great limits on it. And I will tell you, great limits means great restrictions on the profitability or the productive aspect of the land, as it has solar on it. The second part is that Helen Anthony, the previous attorney from Handy Law, referred to a North Kingstown case. Let me put a little, explanation behind that. That involved the giant wind turbine that you see to the right of the Walmart on the corner of Route 102 and Route 2. I'm sure that some of you may have an opportunity to use that Walmart as opposed to maybe Westerly's. Town of North Kingstown said it's worth whatever the hell it was, $1.2 million. So they taxed it for $1.2 million. They said it was equipment and it was tangible property, just like the desk that I sit at now in my office and the computer that I speak into and watch. That is taxable in the same way in the town of North Kingstown, because I happen to be in the town. That's where my office is. Went to the Supreme Court. The Supreme Court, especially Judge Goldberg, said, that equipment, that wind turbine is part of the production of electricity. And that's what it does. So as business equipment, it can't be taxed. It manufactures something. My desk doesn't manufacture anything. And my computer doesn't really manufacture anything. I use that, but it's not part of manufacturing something. So the temporary tax assessor, that may give you some sense, some feeling as to what it was that the Supreme Court meant in that decision. And that was final. So that's the law. Now the governor's energy office gets involved, the General Assembly gets involved, and they say, well, we got to figure out a way to make it even Steven with the cities and towns. So we're going to come up with, and I'll tell you, this project I'm referring to right now, they expect, depending on what it is that, what coverage, how much land of this two projects can be covered, I can tell you far less than half of the 171 acres, far less than that will be covered with solar arrays. They said, we got to make it even. We got to figure out a way to get some tax money, pay your fair share, as the tax assessor just mentioned. So we're going to say for each megawatt that you produce, this project that I'm referring to right now, Gordon and Teft, the Skunk Hill and Lisa Lane and Arcadia Road, is probably going to be about maybe 15 or 16 megawatts. And that would be $5,000 a megawatt to the town of Hopkinton. And that may increase. It's not going to decrease. It is currently Rhode Island state law and in the Rhode Island General Assembly's passed bills that are part of the Rhode Island general laws. So you're going to get tax money from that equipment. Now, the concept of, well, once you put that equipment on the land, which I'll tell you as reference to the to one of the aspects of this appeal, it's not on there, and I don't expect it to be anywhere near there for at least another year, at least that long. You put, at some point in time, you put the panels down. Well, you're getting money from the panels, you connect them to the land, and the tax assessor's theory is that the land becomes more valuable because of the equipment that's on it. Let's think about that logically. It does have an additional use, the land, and there may be an assessment basis that vision appraisal could come to figure out how much more valuable a piece of property is if it has a solar array on it. But you can't tax both the solar panel when it's already subject to that $5,000 per megawatt as being the basis for which, when it's attached to the land becomes more valuable. It's kind of a circular argument, but the fact of the matter is it's not circular when you're paying the taxes. So if you're paying the $5,000 per megawatt and you're paying for an increase of these levels of the assessed value of that property and the ultimate assessment that you're paying and the taxes related to it, then you're paying twice. And there's no other way to look at it other than you're paying twice. You can talk around that all you want, but you're paying twice. And Helen Anthony is correct. She's got a case in the Supreme Court, a case from Lincoln, and she is correct. There is a bill in the General Assembly right now. And that bill creates limitations on what any municipality in Rhode Island in reference to these type of projects can't tax. And it will be that there won't be any ability to do anything beyond what the original previous assessment was as raw land, in light of the fact that the increase in value, the commercialization, so to speak, for the temporary period of 35 years, if it's used that long, because as soon as the panels are removed, the zone change goes away. So that increase in valuation should not be taxed on top of that land when you put the panels on it. What it should be is, if you're assessing the value of the land, assess it as it previously was before the new assessment, because that's all the land's value. That's all it's worth. The increase in value, if any, which I suggest there is being paid for through the General Assembly's passage of the recommendations of the Office of Energy Resources, $5,000 a megawatt. The next projects, which is Atlantic Control System, Inc., 1, 2, and then James R. Grundy, total of 28 acres. That is a really small megawatt-wise project. I expect it probably will be 4 megawatts, which means it's only going to have the ability to have a valuation of the production of the solar array on it of $20,000. That is the methodology by which the state of Rhode Island and the General Assembly, and ultimately because the impetus came from the Rhode Island Supreme Court. So the two branches of government, the General Assembly and the governor signed the bill. So three branches of government had said this is the way that you should tax solar arrays or green energy. And so it's going to be maybe 4 megawatts. So that'll be another $20,000 a year. But let's look at the three parcels. 0 Main Street. It's 12.9 acres. It goes from 104,600 to 337,300, an increase of 222.646%, or almost $250,000, $232,700. The next one, Atlantic controls 0 Main Street. 106.2 is the previous assessment, 215,200, $109,000 increase, percentage-wise, 102%. That's 12.23 acres. And the last one, which is 3.3 acres, it went from that's 3.3 acres in Hopkinton is probably a house lot. 0 Main Street, the Plat 10, Lot 70, goes from Lot 87. It goes from $79,500 to $188,500, 137.10% or $109,000 increase. So let's take that lot as an example of what I'm trying to explain to the board. It's a 3-acre lot. It could be a house lot. If you got some relief, you might get some density bonus. You might get 2 lots out of it. And so those 2 lots go from being taxed at $79,000 to $188,000 because it's got maybe a third of a megawatt of solar panels on it that would produce electricity. Under any theory set forth by the town, that doesn't make sense. You couldn't find comparables because we all know, I mean, the king of Rhode Island assessments is vision appraisal, and everything is comparables. There's some, small aspects that are unique, but it's comparables unless you're trying to do a financial analysis, which generally speaking, vision appraisal doesn't do. I've had hundreds of these cases in my capacity as a solicitor in other towns. It just doesn't make sense. Now, I will tell you, at full disclosure, the taxes, obviously, in order to preserve your rights, you got to keep paying. And the legislation, if we're looking for a reason why it didn't pass last year, it was the House version of the bill required that if the bill passed, and I'll just focus it in on Hopkinton, but it applies to all 39 municipalities, that the municipality had to pay back the excess taxes that they were charged with standard interest. And that has been removed from this. Totally unfair to a municipality to collect money. And then, I'm familiar, I'm a member of the General Assembly. I've been the solicitor in many towns. I've appeared in your town in several capacities. There's no way that a municipality can do anything other than give a tax credit, but that should be it. We're in the midst of a disagreement now. And you will get to keep all of the taxes until this is resolved by legislation or by an act of or a decision from the Rhode Island Supreme Court. So there's no danger to you. You're actually making money on it. But there is a penalty, obviously, to the landowner. And I believe that a proper view to this project in particular, because this is not plugged in, this doesn't have a CO, and it won't have a CO for another year at least. And that to increase those percentages for this lot, just simply because we received permission or special use permit from the town council to be able to have the opportunity to build solar arrays on that, subject to a process before the planning board that is still in process and yet to be finished, I think is unfair. And I believe that it's arbitrary and it's not consistent with typical assessment procedures that are used by vision appraisals in other cities and towns. And I'd be happy to answer any of your questions.
Where the Grundy property, the last three, Atlantic Control System in Grundy.
Yep.
It says zero Main Street. Can you clarify that a little bit, just so I have in my head, I know where it is?
Well, I've been there. I don't know enough about Hopkinton to know how I got there, but I can tell you one thing that's unique to it. I could throw a football into 95. It literally is the property borders the fence of Route 95.
Actually, the tax assessor is bringing out a map now, so.
Yep.
Fill in tax assessor, get it right.
The Phil.
Temporary.
Oh, Phil.
Not 10. Which lot you looking for?
87, 35, 32.
Yeah. Main Street. 87,
Yeah, 87's on map
I mean by the
10.
glasses,
87.
right there. In relation to, North Road, you go past the town hall.
Yeah.
Whole Valley on the right.
Oh, okay. All right. You know where this is? Or 87, what's the other ones? These are all abutting lots then.
They are.
Atlantic- Yeah.
Yep.
See where those are, Mike? Just up the street here.
Oh, yeah, I use it.
Yeah, yeah.
You can see them.
Yeah.
Pretty visible.
All right, so, yeah, so I'm familiar where the lot is now. We're gonna have the fill-in tax assessor.
The consultant.
Yeah. Okay, sounds- Go ahead, John.
Attorney Craven, thank you for bringing up the windmill in North Kingston. I look at it all the time. And that just goes to show that that is a mechanical process being used to create electricity, which by definition is manufacturing, not even solar or light. Now, if you look at the cards, once you get it looks like how this was done. Once you got approval for a zone change, your value went to $15,000 an acre. Your first $100,000 for your commercial site is there. Anything excess went to $15,000. When you start your project, you dig your first hole and you're starting that project, the value will then change to $22,500 an acre. Then, as it seems, once the project is completed, it jumps to the $45,000 an acre. I have to agree that legislation is needed to fix this so-called problem. But I want to make it clear that the intent of this office is not to collect revenue. The intent is to assess everybody throughout the town fairly and evenly. That's what we've done over all these years. And this is how we approached, the previous assessor approached it that way, and I approach it the same way. It being treated fairly and evenly in my book. And we're always going to have disagreements as to how it's done. You know, if the companies would provide us with the information for income and what they're paying out, it would be nice to help analyze the land, but that's few and far between.
Mr. Craven, you have anything else to add?
Just one comment in reference to what the building official, the tax assessor just indicated. This project has to be approved as to what type of lot coverage the solar panels will be allowed to take presence of or be able to cover. And that has not been decided, and that is still a significant question that's up in the air. And so I couldn't provide you with anywhere near accurate. I would be a guess as to how much income will come from this property and when, because there's another process, and that is tying into National Grid and when they will be prepared with a new substation that isn't scheduled to be built until 2024 to receive the electricity that's being produced by several of these projects in Hopkinton. But thank you very much for your patience, putting up with me. And for a temporary tax assessor, you did a hell of a job. I think you ought to
Well, I
take it
got
on
one
the
more.
road.
I got one more comment to make, Attorney Craven.
Sure.
I'm looking at one of Donnie Gordon's cards.
Yep.
And 16 acres is only being assessed at 3,000 an acre, which it was previously. Only 1.2 is being assessed at the $15,000 rate. To be honest, I don't know why the 16 was only at 3,000 and the 1.2 was at 15. But just by this one card, it looks like it was being treated as only a small portion being done at the moment. So I don't think it was too far out of line, but I'll do some more research and look into it. But thank you
Thank
very
you.
much.
Yes, thank you.
Thank you.
Anyone else?
Bill Landry is not on. Oh, no,
So that's it.
that's it.
Okay.
You just have to approve minutes.
I looked at the minutes.
Okay.
I'd like to approve the minutes from our April 15th meeting.
Second.
All in favor? Aye. Minutes are approved.
I can finally post them. You need to make a motion to adjourn.
Motion to adjourn.
Second.
Aye.
Now we're done.
Thanks, Jeff.